Welcome to Thalira Tales, where stories bloom in silence, carrying emotion, mystery, and hidden truth. Step in and let the tale unfold.
I stood outside the hotel room with 12 roses in my hand. He said he was on a business trip, so I booked the same room and hotel to surprise him. But when I was 8 steps from the door, I heard his voice inside. After tonight, she's worthless. A woman laughed. Your wife still believes it all. I didn't cry. I didn't knock. I just pressed record for exactly 10 seconds. And those 10 seconds made me realize my 8 years of marriage were never real. Thank you for being here. That genuinely means something. Now tell me, where are you watching from? Drop your city or country below. Let's see how far this reaches. This story blends fictional elements with educational intent. Names and details are coincidental, but what this story has to say to you is entirely deliberate. It was a Tuesday evening in early March 2025, the kind of evening that feels completely ordinary right up until it doesn't. I remember the specific quality of the light as I stepped off the train at Union Station. Nashville in early March carries a particular kind of dusk. The sun drops behind the Cumberland Hills and leaves everything in this brief amber pause, like the city is holding its breath before deciding what kind of night it wants to be. I had 12 red roses in my left hand, a rolling carry-on in my right, and the specific warmth in my chest that comes from deciding on impulse to do something generous. 3 weeks earlier, my Aunt Ruth had passed away quietly in her Knoxville apartment, a woman who had survived 2 husbands, 1 house fire, and 30 years of teaching middle school English without losing her sense of humor. Her estate attorney, Harold Voss, had called me the week after the funeral to explain that Ruth had maintained a small savings account separately from the rest of her estate, because she had designated it as a payable-on-death account, meaning the funds transferred directly to the named beneficiary upon her death. Bypassing the months-long court process that governs most inheritances, the money had cleared into my personal checking account 2 days prior. $45,000. Ruth's version of a love letter delivered after the fact. I had not yet decided what to do with it. That afternoon on the drive back from my last patient, it made the decision for me. Fletcher had texted that morning that his architecture conference in Chattanooga was running long. A client dinner had extended into a second evening. He'd be home Thursday instead of Wednesday. Sorry, miss you. It was a perfectly reasonable message. I had received variations of it half a dozen times over the past year. I had believed every one of them. On the way home from the clinic, I passed a florist on 21st Avenue and pulled over. I bought 12 red roses, the long-stemmed kind wrapped in brown paper the way good florists still do it. Then I booked a train ticket on my personal card. Not our joint account, a small instinct I didn't examine at the time. I called ahead to the Joseph Nashville and reserved a room for the night. Then texted my mother in Green Hills and asked if she could keep Sloan until morning. Sloan is my 8-year-old daughter, and my mother is the reason I have ever managed to be a working psychologist and a present parent at the same time. My mother said, of course, no questions asked. She never asks questions, which is one of the great kindnesses of my life. Before I left the house, I dropped Sloan off with her overnight bag and her stuffed rabbit and told my mother I had a work thing. My mother assumed I meant a late session. I didn't correct her. I kissed Sloan on the top of her head. She smelled like strawberry shampoo and didn't look up from her book, and I drove to the station. The Joseph Nashville sits at the corner of Korean Veterans Boulevard and 4th Avenue, a converted warehouse turned luxury hotel that manages the difficult trick of feeling both historic and curated. I had stayed there once before at a psychology conference 2 years prior. I remembered the lobby, dark wood, low brass lighting, the faint smell of cedar, and something floral I could never identify. Walking in with 12 roses felt at the time like the right kind of romantic gesture, the kind of thing that would make Fletcher laugh and pull me in and say something about how I was the most impractical person he'd ever loved. The woman at the front desk was in her late 20s, dark-haired, efficient in the particular way of someone who is good at her job. Her name tag read, Petra Dunning. I gave her my name and told her I was there to surprise my husband Fletcher Whitmore. I believed he had a reservation under the Harmon Development Group corporate account. Petra looked at the screen. Then she looked at me. It was less than a second. A fraction of a pause, the kind that would mean nothing to most people. But I am a licensed clinical psychologist with 10 years of practice reading the micro expressions of people who are trying very hard not to show what they know. That pause was not nothing. She recovered immediately. She told me the reservation was confirmed on the 6th floor. She offered to call ahead. I told her that wouldn't be necessary. I wanted it to be a surprise. She smiled in the way of someone who has just been asked to participate in something they cannot stop. In the elevator, I pressed 6. The doors slid closed. There was a single red rose petal on the carpet near the door, slightly crushed at one edge. I assumed it had fallen from another guest's arrangement. The hotel was running a weekend wedding event. Or so I thought. I remember looking at it and thinking someone else is also carrying flowers tonight. I was wrong about that. The 6th floor corridor was quiet, carpeted in deep charcoal gray, lit by small sconces that left the edges of the hallway in soft shadow. Room 634 was midway down the hall on the right. I could see the door from the elevator slightly ajar, not fully latched, the way hotel doors sometimes rest when the latch hasn't caught. I was 8 feet away when I heard Fletcher's voice. I stopped. His voice low and unhurried, the exact register he used when he was at ease. Then a woman's laughter, not loud but present. The kind of sound a room makes when it has only 2 people in it and both of them are comfortable. Then silence. Not the silence of a paused conversation. The silence of 2 people who have stopped needing words. I stood in that corridor for exactly 10 seconds. I know the duration precisely because I raised my phone without any conscious decision and pressed record. 10 seconds of ambient audio. The hum of the HVAC, the faint murmur of the room, the sound of a Tuesday evening in early March rearranging itself into something I would never be able to unhear. Then I turned around. I walked back to the elevator. I pressed 12. I did not cry. I did not make a sound. I stood in the elevator with 12 red roses and watched the floor numbers increment upward and felt something in my chest go very still, not broken, not shattered the way the movies tell you it should feel. Still. Like a clinical observation that has just confirmed a hypothesis you weren't ready to have confirmed. What I did next surprised even me, and it would change everything that came after. 20 minutes later, I was sitting on the edge of a king-size bed on the 12th floor of the Joseph Nashville, a room I had just checked into under my own name on my own card. With only my name on the reservation. Room 1247 was identical in layout to every other room on that floor. A large window facing the Cumberland River, a reading chair in the corner, a desk with a lamp that cast a warm amber cone across the surface. In another version of this evening, it would have been a romantic room. In this version, it was just a room where I was going to have to figure out what I was made of. I sat on the edge of the bed and did not move for 10 minutes. I want to be specific about those 10 minutes because people often assume that the moment of discovery is the worst part. It isn't. The worst part is the 10 minutes after, when your nervous system is deciding whether to believe what it just learned. I am a licensed clinical psychologist. I specialize in trauma and the architecture of trust. I know, with professional precision, the sequence of what happens to a human mind in the immediate aftermath of a severe psychological shock. First, disbelief, a kind of cognitive static, the mind's firewall buying time. Then dissociation, a slight floating quality, as though you are watching yourself from a foot or two above your own head. Then the specific numbness that precedes grief, which is not the absence of feeling but the presence of too much feeling arriving at once, and the body's emergency decision to delay the processing. I experienced all 3 in sequence. I observed myself experiencing them. That is either professional competence or a very particular kind of loneliness, and, on that night, it felt like both at once. At the 10-minute mark, I opened my bag and took out my notebook. I want to be precise about what kind of notebook this was, because it matters. It was not a diary. It was not a journal of feelings or a record of emotional states. Since my second year of graduate school, I have kept a structured clinical observation notebook, dated entries, precise, timestamps, factual language only, the same format I use for patient case notes. My graduate advisor called it the most important professional habit she had ever taught. I had carried some version of this notebook for 11 years. I opened to a clean page and I wrote March 4th, 2025. 2022. Observed Fletcher Whitmore at the Joseph Nashville Room 634 in the company of an unidentified female. Recorded 10 seconds of ambient audio from the corridor. No confrontation initiated. Emotional state functional. That last line was generous, but it was the most honest clinical assessment I could make at the time. I wrote it that way on purpose. In a civil proceeding in the United States, a divorce, a financial dispute, any litigation where one party decides to make things complicated, both sides have the legal right to request documents the other party holds, including personal journals. If those documents are deemed relevant to the case, it's called discovery, and it is exactly as uncomfortable as it sounds. If my notebook contained entries that read as angry, vindictive, or strategically premeditated, a skilled opposing attorney would use those entries to make me look unstable, biased, or worse. So I wrote only what I had observed. The feelings, the specifics, enormous weight of what it means to stand in a hotel corridor and hear your husband's voice through a door. He forgot to fully close. I kept inside my own skull, where no subpoena has ever learned to reach. Then I picked up my regular phone and texted Fletcher stuck in a late session. Staying in the city tonight. Miss you. He replied within 40 seconds. A single heart emoji. The speed of it landed differently than it would have an hour ago. 40 seconds meant he had been watching his phone. 40 seconds meant he was managing two conversations at once and doing it smoothly, which requires practice. 40 seconds meant the heart emoji was not an impulse, it was an instrument. I set the phone face down on the nightstand. I called my mother on the same phone, keeping everything normal, keeping the same device, keeping the same tone of voice. She picked up on the second ring and told me before I could ask that Sloane had eaten 2 full bowls of pasta, had been absolutely impossible about brushing her teeth, and was now deeply asleep. I told my mother that work had run long. She said she had assumed as much. She told me to get some rest. I said I would. I ordered room service because it seemed like the kind of thing a person does when they are in a hotel room and have not eaten since noon. A club sandwich arrived at 9:30 and sat on the desk. Still wrapped, getting progressively less relevant. By midnight, I had filled 4 pages in the observation notebook. Clinical, precise, time-stamped. The kind of documentation that a court would read as contemporaneous record rather than retrospective reconstruction, a distinction I knew that could matter enormously later. By 2 in the morning, the shape of what I needed to do had begun to assemble itself at the edges of my thinking. Not a plan yet, not with edges and steps and a timeline. More like the first formation of a clinical formulation, the moment when the data points stop being individual and start being a pattern. I had seen this structure before in my work. I just had never been the subject of my own case study. I set the notebook on the nightstand beside the untouched sandwich and turned off the lamp. The Cumberland River was visible through the window, wide and dark, moving south in the way rivers do regardless of what is happening in the hotel rooms above them. I watched it for a while. I fell asleep sometime after 2:30. When I woke at 5 in the morning, the notebook was still on the nightstand, the pen still uncapped. The room was gray with early light, and I already knew with complete clarity what my next step had to be. It wasn't going back to that corridor. It wasn't calling Fletcher. It was going home. I checked out of the Joseph at 6:30. Wednesday morning, settled the bill at the front desk with the same card I had checked in with, and walked out into a Nashville that was still mostly dark. The air had that early March quality, cold enough to mean it, warm enough to promise it wouldn't last. I drove to Green Hills in 12 minutes on empty streets and stood on my mother's porch at 7:05, pressing the doorbell once. My mother answered in her robe, took one look at my face, and handed me Sloane's overnight bag without a word. That is the particular fluency of a woman who raised two daughters and learned, somewhere in the process, that the most useful thing you can sometimes offer is silence and logistics. Sloane came down the hallway, still mostly asleep, one sock on the stuffed rabbit she calls Professor tucked under her arm. She walked directly into my legs and wrapped both arms around my knees the way she has done since she was 3 years old. And I stood there in my mother's doorway holding my daughter and the overnight bag, and felt something in my chest make a sound that I was not going to let reach my face. I buckled her into the back seat. By the time I reached the on-ramp for I-65 South, she was asleep again, head tilted against the window, Professor on her lap, breathing with the complete and undisturbed trust that children carry before the world teaches them otherwise. I drove south in silence and let memory do what memory does when you stop trying to manage it. I keep coming back to the day Fletcher and I got married, May 12th, 2017, at a small venue in East Nashville. A converted Victorian with a garden that had looked exactly the way I had imagined it when we booked it 18 months prior. I was 25 years old. Fletcher was 34. He had stood at the far end of the aisle and watched me walk toward him, with an expression I had read at the time as the specific attentiveness of a man who was not taking a single moment for granted. My clinical training had given me a framework for evaluating attachment styles: secure, anxious, avoidant, disorganized. Fletcher had presented across every dimension I had the tools to assess. As securely attached, consistent in his communication, patient with conflict, unhurried in the way he moved through the world. I had filed him under healthy and proceeded to build a life on that assessment. I remember the week I made partner at the practice 3 years into our marriage, a Tuesday evening in early November. Fletcher had cooked dinner from scratch-roasted chicken green beans, the kind of meal that requires actual time and attention. He'd opened a bottle of Burgundy he'd been saving and told me he was prouder of me than he had vocabulary for. I had looked across the table at him and thought with genuine conviction, this is what it looks like to choose well. I remember sitting across from him at the kitchen table 11 months after that, reviewing the mortgage documents for the Belle Meade property, a 5-bedroom house on Tyne Boulevard. $2.8 million, both our names on the deed. Fletcher had walked me through the tax efficiency of joint ownership, the appreciation trajectory of the Belle Meade market, the way the numbers made more sense structured as a shared asset. He was, among other things, an exceptionally good explainer. I had listened, asked 2 or 3 questions that he answered fluently, and signed where indicated. It occurs to me now, turning off I-65 onto Harding Pike, that I had signed a great many things Fletcher had explained to me over the years: the mortgage, the joint investment account, the updated beneficiary designations on my life insurance policy. He always had a reason. The reasons were always coherent. I had always trusted the architecture. I pulled into the driveway at 7:48 in the morning. The house looked the same as it always looked: cream-colored limestone facade, magnolia tree in the front yard that would bloom in another 6 weeks, the garden light near the mailbox that Fletcher had installed, and I had never learned to turn off manually. I carried Sloane inside, got her settled back in her bed with Professor tucked in beside her, and stood in the doorway of her room for a moment listening to her breathe. 8 years old and completely unaware that the floor plan of her life was being redrawn. I intended to keep it that way for as long as I possibly could. Then I walked downstairs and into Fletcher's home office. I had every right to be there. This was our house, my name on the mortgage, the same as his. My credit history, woven into the deed, the same as his. I had walked into this room dozens of times to drop off mail, retrieve a phone charger, look for the extra set of car keys that always somehow ended up on his desk. The room had never felt like trespassing before. The mahogany desk sat against the far wall exactly as he always left it: clear, surface 2 stacked architecture journals, a mechanical pencil lined up parallel to the edge. And there, Pushed slightly behind the lampstand on the left side was something I had never seen before, a dark leather portfolio. Roughly the size of a legal pad, maybe an inch thick, with a small brass combination lock on the front clasp. No monogram, no label, no business card tucked into the exterior pocket. The kind of object designed to look unremarkable while containing something worth locking. I stood in front of that desk and did not touch it. This was a conscious decision, not hesitation, not fear, but deliberate restraint. I had been in practice long enough to know that how you obtain information matters as much as what that information contains. A locked container belonging to a spouse occupies a specific and genuinely complicated legal space in Tennessee. Opening it by force or without consent could create what attorneys call a chain of custody problem, meaning anything inside might be challenged as improperly obtained, regardless of what it revealed. Fletcher's lawyer, if it came to that, would argue the breach before the jury ever saw the contents. I photographed the portfolio from 4 angles with my phone: its position relative to the lamp, its distance from the desk edge, the small brass lock mechanism in close-up. I measured its position against a ruler from the kitchen drawer and noted the measurement in my observation notebook. Then I went to the kitchen, made coffee, and sat down at the table with my phone. There was one call I needed to make before I did anything else. I called Miriam Calloway at 8 o'clock that Wednesday morning, still sitting at the kitchen table with coffee. I had brewed more out of muscle memory than any real appetite for it. Miriam is a family and asset attorney here in Nashville, 50 years old, 25 years in practice. The kind of lawyer whose hourly rate tells you exactly how seriously she takes her own time. I had referred 3 patients to her over the years, when their situations outgrew what therapy could address. She had always been precise, always without sentiment, and she had never once softened a legal reality to make a client feel better about it. At 8 in the morning on a Wednesday, when my life was reorganizing itself without my permission, that was exactly the quality I needed. She picked up on the second ring. I gave her 60 seconds of context. She let me finish without interruption, then said, "Before you touch anything in that office, I need you to hear this. You are a co-owner of that property and a legal spouse in Tennessee, which gives you right of access to shared spaces. However, if you force open damage or circumvent a locked container, anything inside becomes potentially inadmissible, and you hand Fletcher's attorney a counterclaim before you've even filed. Photograph the exterior document, its position, and do not open it." I told her I had already done both. She said, "Good. That's your first sound decision in the last 12 hours. I asked about the legitimate path to the contents. She told me a civil discovery motion filed once divorce proceedings were initiated would compel disclosure under court supervision. Alternatively, a voluntary disclosure request through a neutral mediator faster, but requiring Fletcher's cooperation, which she noted I should not currently count on. Neither was happening today. Today was documentation. I hung up and moved to the filing cabinet. It was a standard 4-drawer legal cabinet against the left wall. Dark gray, never locked a cabinet I had opened probably 40 times over the course of our marriage for tax returns. Insurance renewals, the deed, copies we'd needed twice for refinancing. I had a key on my own keychain. I had never thought of it as his. Behind the mortgage folder in the 3rd drawer, tucked flat against the back panel, was a manila envelope I had never been shown. I put on a pair of latex gloves from the kitchen, the kind I keep for cleaning, before I touched it. A small instinct, and the right one. Inside the envelope was a life insurance policy. The insured party listed on the cover page, Nadine Whitmore. Policy value $4 million. Issue date 3 months prior. Sole beneficiary, Fletcher Whitmore. I set it on the desk and photographed every page. Then I called Miriam back. She was quiet for a moment after I read her the details. Then, Nadine in every state in this country. The person being insured must provide written consent and submit to a medical examination before a high-value policy like this can be issued. The insurance company is legally required to obtain that signature directly from the insured, not from the applicant. If your signature appears on this document, it was forged. If it doesn't appear at all, the policy is void from inception and constitutes insurance fraud at the point of application. Either way, this is a criminal matter that exists completely separately from your divorce. I checked the signature line. The handwriting was close to mine, the particular way I form the capital N, the slight leftward lean on the W. Someone had studied it carefully. It was not mine. I told Miriam. She told me to photograph the signature line in close-up and send it to her separately. Then she said, "Do not mention this to Fletcher. Do not mention it to anyone." This moves the situation from a civil proceeding into potential federal criminal territory, and I need to make some calls before we decide how to handle it. I replaced the envelope exactly as I had found it, behind the mortgage folder flat against the back panel at the same angle. In the folder behind the one labeled Arch Conferences, I found 11 travel itineraries, all from the past 9 months, all to cities Fletcher had never mentioned. Each one had a hotel confirmation attached. Each confirmation had the same 2 initials written in the margin in Fletcher's handwriting, CH. I photographed all 11. I closed the drawer. I put the latex gloves in my coat pocket to dispose of away from the house. Then I went back to the kitchen, sat down, and picked up my phone one more time. Archer Slade has been a licensed private investigator in Tennessee for 17 years. I have known him for 10. We met through a mutual colleague when I was still in my residency, and he has been, in the specific way of people who show up without being asked, one of the most reliable people in my life. He does not editorialize, does not exaggerate, and does not tell you things are fine when they are not. He answered on the second ring. I said 4 words, "Archer, I need you." He said 2, "I'm coming." What he would bring with him that evening would make the insurance policy look like the least alarming document in that drawer. Archer Slade arrived at 6:30 Wednesday evening, carrying a laptop bag over one shoulder and a takeout container of chicken soup from a place on Charlotte Avenue that he swears makes better soup than his ex-wife ever did, which, based on what I know about that marriage, is not an especially high bar. He set the soup on the kitchen counter without asking if I was hungry, which was the correct move, because I was not going to say yes and I needed to eat. Then he sat down across from me at the table, opened his laptop, and said the thing he always says before he opens a case file. "Everything I'm about to show you came from public records licensed commercial databases, and one document provided voluntarily by a source. Nothing was obtained through unauthorized system access. I want that stated between us because I know you're going to want to use this. I have been relying on Archer Slade for 10 years, and in that time I have never once had to question where his information came from. He runs a licensed private investigation firm out of a small office on 8th Avenue South, and he is one of those rare people who understands that the way you obtain information matters as much as what that information contains. In a federal courtroom, evidence gathered through illegal means gets thrown out before the jury ever sees it. Archer has never given me anything that couldn't survive a judge's scrutiny. That discipline is the reason I called him this morning and not someone else. He turned the laptop toward me and began. The first document was a corporate filing for Whitmore Design LLC Incorporated in Delaware, 18 months prior, publicly searchable through the Delaware Secretary of State's online database. Delaware is where roughly half of all American corporations are registered, including a significant number of shell companies, because the state's business laws are flexible and its disclosure requirements for actual ownership are minimal. What the filing showed: a registered agent in Wilmington, a standard Delaware service company, no names attached to the ownership, but the registered office address, the physical location the LLC had listed for business correspondence, matched a floor in a commercial building in Chattanooga where Harmon Development Group leased space. He let me sit with that for a moment before he moved to the second document. A UCC filing Uniform Commercial Code, he explained without my asking, a public record that any person or business can access, used to register a financial interest in commercial assets. What this one showed was a cross-reference between Whitmore Design LLC and a financial instrument registered to a holding entity in the Cayman Islands. The Cayman connection meant money had moved offshore through a structure designed to be difficult to trace. The UCC filing itself was the breadcrumb that made the connection visible. "This is all public record," Archer said. "The filing is dated 14 months ago. Whoever set this up was careful, but they used the domestic registration system to anchor the Cayman entity, which left a paper trail in a database anyone can search." I asked him about the initials. He told me. Celeste Harmon, 44 years old, CEO of Harmon Development Group, a real estate development firm headquartered in Chattanooga with operations across the Southeast. Annual revenue approximately $340 million. She had been named, Archer told me, in a private civil arbitration proceeding that had since been settled under a non-disclosure agreement. An NDA seals the contents of a settlement, but the existence of the proceeding itself, the fact that it was filed, that parties were named, that it was resolved, remains part of the public record. He had found it through a licensed legal database. The name Celeste Harmon meant nothing to me. The initials CH now meant everything. Then Archer told me about Conrad Harmon. Conrad was Celeste's former husband, 44 years old, formerly the principal of a mid-sized commercial development firm based in Nashville. 14 months ago, he had filed for Chapter 7 bankruptcy listing as a primary cause, the loss of a major construction contract. That contract, per the public court filing, had gone instead to Whitmore and Associates, Fletcher's firm. I sat with that for a moment longer than I had sat with the other things. Archer closed one window on his laptop and opened another. He turned it toward me again, a printed property record. A licensed search result showing a property registered under Whitmore Design LLC at an address in a city I had not expected. He did not tell me which city when he handed it to me. He told me, "I pulled this from a licensed property records database. It's admissible, but I need you to not go there yet. Not until we know what we're actually looking at." I looked at the address. I set it face down on the table. I ate the soup. I didn't taste it, but I ate it. Sloane had woken around noon that day, come downstairs in her pajamas, eaten half a grilled cheese sandwich, and gone back upstairs. She had been asleep again since 2 in the afternoon, which was unusual even for her. Children have a specific sensitivity to the emotional temperature of a house they can't name. What's wrong can't locate the source of the discomfort, but they feel it the way animals feel weather before it arrives. I had checked on her twice. Both times she was sleeping with one hand flung out toward the edge of the mattress, the way she sleeps when something in her small body is trying to hold on. I did not tell Archer about Sloane. He already knew. He has known our family for years. He stayed until 9 o'clock, then packed up his laptop, told me he needed 48 more hours to run the full financial chain, and let himself out the front door. I stood at the kitchen window and watched his taillights disappear down Tyne Boulevard. The weekend that followed passed in a strange suspended quality, not silence exactly, but the specific stillness of someone who has stopped reacting and started waiting. I worked Saturday morning. 3 patients back to back, 2 of them navigating their own versions of betrayal, and I sat across from their pain with what I hope was professional competence and what I know was considerable personal effort. I said nothing to anyone. I kept my regular phone active and normal and full of ordinary messages. I texted Fletcher twice, once about a utility bill, once a photograph of Sloane in the backyard, and he responded warmly both times within minutes. By Sunday evening, I had read Archer's preliminary report twice and slept approximately 11 hours total across 2 nights. Monday morning, I had an 8 o'clock appointment on Commerce Street with a woman I had referred clients to for years but had never sat across from myself. I wasn't bringing roses this time. Miriam Calloway's office occupied the entire 14th floor of a building on Commerce Street, with floor-to-ceiling windows on the north wall that looked directly over the Cumberland River. The river was slate gray that morning, moving south in the unhurried way it always does, regardless of what is happening in the city above it. I stood at the window for a moment before I sat down, because I needed 30 seconds of something that wasn't moving. I had never sat on the client side of Miriam's conference table before. I had referred 3 patients here over the years, sat in the waiting area once, while one of them signed paperwork. Stood in the hallway briefly after another appointment, but I had never been the one setting documents on that table. The conference table was 12 feet long, polished dark wood, with a leather portfolio and a legal pad already positioned at Miriam's end. She was 50 years old, silver-streaked hair pulled back, reading glasses on the chain around her neck that she only put on when she was about to look at something closely. She gestured for me to sit. I laid everything out in sequence: the photographs of the filing cabinet documents, Archer's public records research printed and annotated, the close-up photographs of the insurance policy signature line, and my observation notebook, the structured clinical record I had been keeping since Tuesday night, time-stamped factual, written in the same format I use for patient case notes. Miriam reviewed the notebook first. She read without speaking for approximately 4 minutes, the kind of reading where you can tell someone is not just absorbing content, but evaluating it. Then she set it down and looked at me over the top of her glasses. She said, "This is written in clinical notation. Factual observations, timestamps, first-hand accounts only. I want to be direct with you about what this document is and what it isn't." She folded her hands on the table. In any civil proceeding, a divorce, a financial dispute, both parties have the right to request documents the other side holds, including personal journals, if those documents are deemed relevant to the case. That process is called discovery, and it applies to this notebook. If there is a single entry in here that reads as planning scheming or emotional bias against Fletcher, his attorney will use it to characterize you as vindictive and strategically motivated. That characterization damages your credibility as a witness and potentially your professional standing as well. She paused. What this notebook currently is, provided you maintain this discipline, is a contemporaneous record of your own direct observations. That is a recognized evidentiary format in Tennessee civil proceedings. It is not a diary. It is not a record of intent. It is a log. Keep it that way. Then she told me about the second document. From this point forward, she said, you maintain 2 separate things. First, this notebook in the same clinical format, strictly observational, no emotional content. Second, a private handwritten journal that you will keep here in my office, in a locked drawer. You write whatever you actually feel in that journal, the anger, the grief, whatever it is. That journal is protected by attorney-client privilege. It never gets photographed, never gets transmitted, never enters a courtroom. It exists to protect your mental health while keeping the observation record clean. I understood the distinction immediately. I recognized the same principle I use with certain patients: one document for the clinical record, one space for the human being inside the clinical record. I wrote across the inside front cover of the observation notebook in capital letters, "Factual record only, not a diary." Miriam moved to the insurance policy photographs next. She reviewed the signature page in silence, then set it aside with a particular deliberateness that told me she was filing it in a specific mental category. I spoke with a colleague in insurance law Friday afternoon. She said, in Tennessee, as in every state, a life insurance policy of this value requires the written consent of the insured party obtained directly and independently from the applicant, as well as a medical examination completed by the insurer's designated physician. The insured must sign the application themselves. If the signature on this document was not made by you, it constitutes fraud at the point of application, which is a criminal offense under both state and federal insurance statutes. I am treating this as a parallel criminal matter separate from the civil divorce proceedings. She picked up the marriage contract next, a document Fletcher had drafted in the first year of our marriage, which I had signed without hiring my own attorney to review it first. Miriam found 2 clauses that lacked an independent counsel certification on my side of the agreement. She explained, in Tennessee, a marital agreement is not automatically void because one party lacked independent legal counsel, but the absence of that counsel gives the court grounds to scrutinize those specific provisions more carefully. particularly if one party can demonstrate they didn't fully understand what they were signing. She told me the two clauses related to asset division in the event of dissolution. She said, "We'll challenge both." Before I left, she handed me a disposable phone, a standard prepaid device with two numbers preloaded into the contacts, her direct line and Archer's. She told me to use my regular phone for everything that needed to look normal, texts to Fletcher calls, to patients anything that might later be reviewed. The disposable phone was for anything that shouldn't be. She walked me to the elevator herself, which she doesn't usually do with clients. At the door, she said, "You're going to want to move fast. But the people who move carefully in the first 30 days are the ones who are still standing at the end of this." I told her I understood. The elevator doors closed. I was alone descending 14 floors toward Commerce Street when my regular phone buzzed in my coat pocket. Adeline Cross. A text message sent at 8:52 in the morning. "Hey, haven't seen you around. Everything okay with you and Fletcher?" I want to explain who Adeline Cross is because the name matters. She was my closest colleague at the practice, 38 years old. A clinical psychologist specializing in anxiety and relational attachment, someone I had worked alongside for 4 years. We had shared late nights, co-managed difficult cases, eaten lunch at the same table so many times that the staff called it our table. I had trusted her. In the specific way you trust someone who works beside you in a profession that requires a baseline of shared integrity. I read her text twice. There is a specific internal calibration that I experience before a clinical diagnosis resolves, a quiet shift at the back of my thinking, like a gear finding its slot. It happens before I can articulate why. It happened now. Adeline had no particular reason to ask about Fletcher. She had never asked about Fletcher. Her text had arrived 47 minutes into a Monday morning before I had been at the office, before I had spoken to anyone at the clinic. I did not reply. I opened my observation notebook to a new page and wrote the timestamp March 10th, 2025, 8:52. Received text from Adeline Cross inquiring about Fletcher Whitmore. No prior context. No prior pattern of such inquiries. Noted. Then I put both phones in my coat pocket and walked out into Commerce Street. By the time I pulled into our driveway that Monday afternoon, I had been awake for 34 hours and had made more consequential decisions than I normally make in a month. I walked into the house, changed out of my work clothes, and stood in the kitchen making tea with the specific deliberateness of someone preparing for a performance they cannot afford to give badly. Fletcher came home at 6:15. He brought food from Margot, a French Southern restaurant on Elliston Place that we had been going to since our second year of marriage, the kind of place that feels like a shared possession rather than just a restaurant. He also brought tulips, a small mixed bouquet, pink and yellow, wrapped in the pale green paper of the florist on 12th Avenue. Tulips are my least favorite flower. They are the only flower I have ever explicitly mentioned disliking. In a conversation I remember clearly because we had been together for 3 months at the time, and I had assumed the information would register. 8 years later, tulips. I told him they were beautiful. Sloane was at the kitchen table when he came in, working a floor puzzle of the solar system that she had been assembling in stages for 2 weeks. She heard the door and came off that chair, like she'd been launched full sprint across the kitchen, both arms out. The specific velocity of an 8-year-old who has not yet learned to moderate enthusiasm. Fletcher caught her and swung her in a full arc, and she screamed with the uncomplicated delight that children produce before the world teaches them that joy needs to be calibrated. I watched this from across the kitchen and felt the particular cruelty of knowing something that everyone else in the room does not. Not anger that would come later in more manageable installments. What I felt in that moment was something closer to grief. The understanding that the warm, laughing man, spinning my daughter across the kitchen floor, was also the man who had forged my signature on a $4 million insurance policy and spent 9 months lying about 11 separate business trips. Both of those things were equally true, and I was the only person in that room who knew it. Dinner was performed well by both of us, though only one of us was performing. Fletcher talked through the meal with the ease of a man who has nothing to conceal. The Chattanooga conference, a presentation that had gone better than expected. The Harmon development account moving toward what he described as a significant milestone. He mentioned that he was considering bringing on an associate architect, that the workload had grown past what one person could manage alone. He was warm, expansive, generous with eye contact. He asked about my week with the specific attentiveness he had deployed for 8 years. And I described a patient scheduling issue and a grant application deadline in sufficient detail that the answer sounded real without being informative. After Sloane went upstairs, I poured Fletcher a second glass of wine and waited until the kitchen was quiet. Then I told him carefully and without specifics that I had been feeling some distance between us lately, that it had been on my mind, that I wanted to say it rather than let it sit. I knew what was coming. I had spent 36 hours knowing what was coming. Knowing did not fully prepare me. He set down his glass. He said, "Nadine." Just my name with the particular intonation of patient concern. Then, "I've been worried about you. You've been somewhere else for weeks, I've noticed it, and I didn't want to push. But since you're bringing it up, you've been stretched thin with the expansion. I've been trying to give you space." In clinical literature, the pattern is called Darvo deny attack reverse victim and offender. It is a documented psychological response, most commonly observed in individuals who have been confronted directly or indirectly about harmful behavior. The sequence is consistent first. Deny the behavior or minimize it. Then attack the credibility or emotional state of the person raising the concern. Then reverse the framing entirely, repositioning the offending party as the actual victim and the confronting party as the source of harm. I had taught this pattern in a workshop at Vanderbilt 2 years ago. I watched Fletcher deploy it in real time with the precision of someone who had practiced it. And I felt something happen in my chest that I can only describe as a near miss, the sensation of a clinical conclusion, almost arriving before the professional override kicks in. The particular evil of gaslighting is not that it works on people who don't know better. It is that it works on people who do. The mechanism bypasses the analytical mind and lands somewhere older and more vulnerable, the part of you that wants the simpler story to be true. The part of you that built a life on a particular version of a person and does not want 8 years of architecture to be load-bearing fraud. I held his gaze across the kitchen table and let the moment pass through me rather than into me. I smiled. I told him I appreciated him saying that. I said I was probably right about the expansion stress, that I would try to be more present. I reached across and covered his hand with mine for exactly 3 seconds, which is how long it took before I trusted myself to let go. I refilled his wine. Then I excused myself to check on Sloane. She was already asleep, one sock off, Professor the Rabbit tucked under her arm at a precise right angle she had maintained since she was 4 years old. I stood in her doorway for a moment in the dark. 8 years old, 42 pounds, completely unaware that the ground plan of her life was being quietly redrawn in the kitchen below her. I intended to complete the process before she ever needed to understand what had happened. In bed, Fletcher fell asleep within 20 minutes. I lay beside him and reviewed Miriam's instructions in sequence observation notebook, factual only. Disposable phone, operational matters only. Regular phone, everything normal. Say nothing to anyone at the clinic. I watched the ceiling and thought about Adeline's text. Everything okay with you and Fletcher, and the timestamp I had noted in my notebook, 8:52 a.m. 47 minutes into a Monday morning when she had no particular reason to ask. I did not arrive at a conclusion. I noted the data point. At 7 the next morning, my regular phone rang, not the disposable but the everyday number that Reese has called since she was old enough to dial. My younger sister, 26 years old, finishing her master's in financial analysis at Vanderbilt's Owen Graduate School of Management. She almost never cries. She was crying. She said she needed to see me, that it was about Fletcher, that she had been carrying something for 8 months and she couldn't hold it alone anymore. I told her I would be at the clinic in an hour. I went downstairs and told Fletcher I needed an early start. Could he do school drop-off? He said, of course, no problem, handed me a travel mug of coffee he had already made and kissed me on the cheek. I drove to work thinking about all the small daily kindnesses that can exist alongside an 8-year deception. The coffee he made, the door he always held, the way he remembered every restaurant preference of mine and forgot every flower. What Reese had been carrying alone for 8 months was not something any 26-year-old should have had to hold. Reese was already in my office when I arrived. She was sitting in the patient chair, the one directly across from my desk. The chair I have pointed hundreds of people toward over the years when they needed a safe place to say something difficult. She had never sat in it before. Her laptop was open on her knees, and her hands were clasped in her lap in the particular way we both used to sit in the third pew of Riverside Church when we were children and something was about to be said that could not be taken back. I closed the door behind me, set my bag on the desk, and sat down in my own chair. For a moment, we just looked at each other across the space that was usually reserved for people in crisis. "How long have you been here?" I asked. "Since 7, she said. I didn't want to wait in the car. She had been crying earlier. I could see it in the particular tightness around her eyes, the way she had already worked through whatever she was going to say and arrived at something beyond the tears. Reese does not cry easily. When she does, it means something has been pressing on her for long enough that the pressure finally found a release. 8 months was a long time to press. She turned the laptop toward me and began. She told me she had been working through a financial forensics assignment for her graduate seminar at Vanderbilt, a course that required students to apply analytical methods to real transaction records rather than textbook examples. She had used our household tax files, which I had given her access to 2 years prior when she was studying for her Series 65 licensing exam and needed examples of legitimate investment documentation. She had not thought twice about pulling them out again. "I was looking at the Schedule C deductions," she said, "and I noticed outflows from the joint checking account that didn't match any business receipts I could find in the filings. Small amounts, 400 here, 600 there, but they were consistent. Same intervals, same destination account. I thought it was a category error. I pulled the thread anyway." She told me what she found when she pulled the thread. Over 14 months, 297 individual transactions had moved a combined total of just under $340,000 from the household joint account to a corporate account she could not initially identify. The amounts were structured to stay below the threshold that triggers automatic bank reporting under $10,000 each, dispersed across irregular intervals to avoid pattern recognition software. She had recognized the structuring method from a case study on financial fraud her professor had assigned in the fall semester. "I built the spreadsheet to make sure I wasn't misreading it," she said, and turned the screen toward me. 300 rows, color-coded by transaction date, cross-referenced against Fletcher's publicly filed Schedule C receipts. The gap was not a rounding error. The gap was not a misclassification. The gap was a deliberate, methodical redirection of money from an account we both had our names on to somewhere neither of us was supposed to notice. "Reese," I said, "that LLC, the destination account, it's registered to a company called Whitmore Design." She closed the laptop slowly, like someone taking a careful breath. Then she said, "I know. I found the incorporation papers 2 weeks ago. I pulled the Delaware Secretary of State records. It's public access. Anyone can search it. The registered agent is a service company in Wilmington, but the correspondence address is a building in Chattanooga." She paused. "Nadine, the LLC isn't registered to Fletcher. The principal on the Delaware filing is a woman named Celeste Harmon." I had already known Celeste Harmon's name for 5 days. Knowing it did not make hearing it from my sister's mouth any easier. There is a difference between information held in the professional part of your mind and information that arrives through someone who loves you. The second kind lands differently, lands in parts of you that clinical detachment doesn't fully reach. I sat with it for a moment. Then I asked Reese the question I needed to ask. "Have you told anyone else? Anyone at Vanderbilt? A professor? A classmate?" "No," she said. "Nobody." I almost told you in July, then in October, then again at Christmas. She looked at the closed laptop. Every time I thought about saying it, I told myself it was probably a mistake, that there was an explanation I hadn't found yet, that you were happy and it wasn't my place to. She stopped. I'm sorry, Nadine. I should have told you the moment I found it. I reached across the desk and put my hand on hers. The psychology of protective silence is something I understand well. People withhold information that will cause pain, not because they are cowards, but because they love the person they are protecting and cannot reconcile the love with the damage the truth will do. Reese had carried this for 8 months because she is 26 years old and she adored her brother-in-law, and she could not make those two realities coexist. That is not a character flaw. That is what love does to people before experience teaches them that the truth is kinder than the weight of carrying it alone. I asked her to send the spreadsheet directly to the disposable phone, not email, not a shared drive, a direct transfer from her device to mine. She did it immediately, right there across the desk. The file moving between our phones while I watched the progress bar. 300 rows of evidence built by a 26-year-old financial analysis student working a graduate seminar assignment who had loved her sister enough to eventually tell the truth. Before she left, Reese stood and held my face in both hands, the same gesture she has used since I was 8 years old, and she was 4, and somehow already convinced it was her job to steady me. She said, "Whatever you're planning, please don't do it alone." I told her I wasn't alone. It was becoming more true by the hour. She left at 8:45. I sat in my office for a few minutes after the door closed, looking at the patient chair she had just vacated, and thought about how many people had sat in that chair over the years and handed me the worst thing they knew, and how it was different completely. Entirely different when the person handing it to you was someone whose whole life had been in the same frame as yours. That afternoon, my disposable phone buzzed with a call from Archer. He had a name I hadn't heard before. A name that transformed everything that had felt like financial crime into something that reached much further back and cut much closer to the bone. Before I tell you what Archer found next, and I want to warn you, this one is harder to hear than anything before. It comment the word, "still here," so I know you're with me, because what comes next changes the entire shape of this story. A quick note. Some elements in this story are fictional, shaped for narrative and educational purposes. If that's not something you want to continue with, this is a comfortable place to stop. No hard feelings. Archer had called once that afternoon around 4:30 to tell me he needed another few hours to verify something before he could present it. He said, "I want to be certain before I say this one out loud." That was unusual for him. Archer is not a man who hedges. I told him to take whatever time he needed and went back to my last 2 patients of the day with the specific concentration of someone who has learned through long practice to keep 2 things running in separate lanes. By 7 o'clock, the clinic was empty. The corridor lights had shifted to their automatic evening setting, the low, amber-toned mode that the building management activates after 6 to reduce energy costs, and that always makes the hallway feel slightly like a waiting room for something. I was still at my desk. Observation notebook open, reviewing what I had documented over the past 7 days when the disposable phone rang. Archer's voice was quieter than usual. With Archer quiet means the information is heavy. He told me he had completed the full account trace. Starting from Whitmore Design LLC, the money moved through 2 Delaware shell entities, both registered to the same Wilmington Service Company. Both incorporated within 6 months of the original LLC and terminated in a set of accounts held by a Cayman Islands trust structure. The confirmed total across all accounts, $8.3 million accumulated over approximately 22 months. The Delaware chain is public record, you already have that, he said. What I added was the Cayman Bridge. That came from a licensed financial intelligence service subscription access, fully documented. I have the receipts. Nothing in this chain came from unauthorized access to any system. He also told me that 3 of the account numbers in the Cayman structure appeared in a public enforcement database maintained by the Financial Crimes Enforcement Network FinCEN, which is the division of the U.S. Treasury that tracks suspicious financial activity reported by banks under the Bank Secrecy Act. The accounts had been flagged in a 2022 suspicious activity report, meaning a bank had already noticed the pattern and filed a report as required by law. The FBI's Financial Crimes Unit would have received a copy. They had an open parallel file. Fletcher didn't create something new, Archer said. He used a structure that already had federal eyes on it. He just didn't know that yet. I wrote the number in my observation notebook, $8,300,000. FinCEN flag 2022. FBI parallel file active. Then Archer said, "There's something else, and I want you to hear all of it before you respond." He told me about Wren Dunning. "There is a woman working the front desk at the Joseph Nashville," he said. "Her name is Wren Dunning. She is 28 years old, and her mother's name was Carol Dunning." I recognized the last name immediately. Petra Dunning, the receptionist who had been on duty the night I arrived with roses. The woman who had paused for less than a second when I said my name. I had filed that pause away and not yet returned to it. Archer told me that Wren and Petra were sisters. Petra had worked at the Joseph for 3 years. Wren had joined the staff 4 months ago, shortly after she applied for an administrative position at Whitmore and Associates Architecture, and was turned down without interview. She had not come to the Joseph by accident. Archer explained carefully, having verified the details across multiple sources, before calling me that Carol Dunning had been the owner of a small commercial catering business in Memphis. In 2015, she had contracted a Nashville architecture and design firm to rebuild her primary commercial property, a leased warehouse she had been converting into an events space for 5 years. The firm was Whitmore and Associates, Fletcher's firm. The project ran over its contracted budget by $680,000 over 14 months. The overruns were documented in invoices that Fletcher's firm issued to Carol directly. Categorized as unforeseen structural costs. The money was paid. The money went into a corporate disbursement account that was subsequently closed. The structural work was never completed to the specifications of the original contract. Carol Dunning lost the property. She lost the business. She lost everything she had built over 17 years. In January of 2017, she died by suicide. Wren was 19 years old. I sat with that information the way I sometimes sit with a patient disclosure that changes the entire shape of a case, not reacting immediately, not reaching for the professional response, just letting the weight of it settle into its actual dimensions before I tried to do anything with it. I have spent 10 years working with people in the aftermath of loss. I know what it costs a person to carry the story of a parent's death, especially that kind of death, for 8 years. I know what it does to a 19-year-old to watch a system absorb the cause of that death without consequence. Wren Dunning had been 28 years old and working the front desk at the hotel where my husband held his rendezvous, and she had looked at my name on her screen and paused for less than a second. "Does she know who I am?" I asked. "She knows Fletcher Whitmore's wife is a psychologist named Nadine," Archer said. "She's known that for about 2 years. She's been watching the firm." The letter I said. "Her mother left a letter," Archer confirmed. "Wren has it. I spoke with her briefly. She approached me, actually, sheesh, after I identified myself as a licensed investigator with a professional interest in Whitmore and Associates. She's been waiting for someone to give her a reason to use it." He said the decision of what to do with that letter, whether to ask for it, whether to involve Wren further, was mine to make. I told him I wanted to meet her. He said he would arrange it. I stayed at my desk for a few minutes after we hung up, looking at the notepad where I had written Carol Dunning's name and thought about the specific arithmetic of what Fletcher had done. A woman loses her business, loses her livelihood, loses her life and the money that caused it, moves through 3 shell companies, and ends up in a Cayman trust that a federal agency has been watching since 2022. No consequence. Not for 8 years. Not until now. I drove home that night thinking about Ren Dunning in a hotel lobby, 4 months of shifts behind a front desk waiting. The kind of waiting that has no guaranteed end. The kind of patience that is really just grief that has nowhere else to go. Before that meeting could happen, though, something much closer demanded my attention, because by Wednesday morning I had specifics. Documentable reason to believe that someone inside my own clinic had been telling Fletcher things they should not have known. I drove the rest of the way home in silence. By midnight, I had read the intake form twice, printed it on the home printer, while Fletcher slept upstairs and locked it in the bottom drawer of my desk. I did not write about it in the observation notebook. Some information is too provisional to document until you know what it means. I already knew what it meant. I needed 3 more days to be certain. By the second Wednesday of March 12th, I had read the intake form a third time that morning before leaving the house. The printout was locked in the bottom drawer of my desk. I arrived 40 minutes early and sat in my car on the third level of the parking garage on 21st Avenue, engine off, watching the clinic entrance the way Archer had taught me to watch things not for what was moving, but for what was trying not to. And sat in my car on the third level of the parking garage on 21st Avenue, engine off, watching the clinic entrance the way Archer had taught me to watch things not for what was moving, but for what was trying not to. The garage had a partial sightline to the clinic's main entrance on the ground floor, the glass doors, the reception area visible through the lobby window, the small courtyard where staff sometimes took calls between sessions. I had never thought of it as a surveillance position before. I thought of it that way now. At 7:43 in the morning, I watched Adeline Cross arrive. She was 20 minutes ahead of her first patient, unusual, but not impossible. What was notable was the direction she went. Through the lobby, past the reception desk, and left toward the file room, not right toward her own office. The file room held administrative record scheduling systems, and the clinic's internal server terminal, the physical access point for our document management system. I wrote the timestamp in my observation notebook and added 3 words: direction file room. I want to be clear about who Adeline Cross was to me at that point, because the information I received later that afternoon would require me to recalibrate 4 years of professional trust in a single afternoon, and that process deserves accuracy. Adeline was 38 years old, a licensed clinical psychologist specializing in anxiety and relational attachment. We had shared this practice for 4 years. She had covered my patients during my appendectomy 2 summers ago. She had read the first draft of my journal article on coercive control dynamics and given me notes that made it materially better. She was not a peripheral colleague. She was the person I trusted most in this building. That afternoon, Archer's report arrived on the disposable phone. I had signed the server access authorization the previous Monday, co-director's privilege, HIPAA compliant, Miriam's countersignature on the chain of custody form. He had reviewed only system-level logs. No patient records touched. The report confirmed what I had begun to suspect since Tuesday 7, encrypted outbound transmissions from Adeline's clinic device, same destination each time, spanning 6 weeks. The last one had been sent 3 days ago, the day after my Commerce Street meeting with Miriam. Archer's note at the bottom of the report read, "Someone told him you'd been to see a lawyer." I sat with that sentence for a long time. In the 9 years I have been in clinical practice, I have developed a fairly precise internal instrument for the moment a diagnosis resolves, when the scattered data points stop being individual observations and become a coherent clinical picture. The sensation is specific, a kind of settling, like a lens finding its focus. It is usually accompanied by a quality of calm that my graduate supervisor once called the psychologist's occupational hazard, the equanimity that arrives when you finally understand something terrible. I experienced it then. 4 years of shared late nights and conference submissions and difficult cases reorganizing themselves into a pattern I had not wanted to see. I did not confront Adeline. This was a deliberate decision, not an emotional one. Confronting her would tell Fletcher that I knew. Telling Fletcher that I knew would collapse the investigation before we had assembled enough to make it irreversible. So instead, at 5:30 that afternoon, I walked down the hall to her office with 2 cups of coffee, hers, with oat milk, the way she has taken it for 4 years, and spent 30 minutes discussing the co-managed case we had been working through for the past month. I asked questions I already knew the answers to. I listened with the specific quality of attention I extend to people I believe. I smiled twice. She smiled back. She had no idea. I walked to my car at 6:15 and sat in the driver's seat for a moment before starting the engine. The most disorienting aspect of working in psychology is not the difficult cases. It is the occasional realization that the analytical tools you have spent years developing can be turned against you by someone who has studied them. Adeline Cross had sat across from me for 4 years learning exactly how I thought, and had used that knowledge to give someone else a map of my movements. That was not merely a professional betrayal. That was a specific, calibrated architecture of harm, and it had been built inside the same walls where I spent my days, helping people recover from exactly that. I drove home on autopilot, taking the back route on Hillsborough Pike, the way I do when I need 20 minutes to think before I walk through my own front door. Halfway down Hillsborough, my personal email notification appeared on the phone in the cup holder. Not the disposable phone, but my private address, the one I give to almost no one. The sender field showed a Proton mail address I didn't recognize, a string of random characters with no identifying information. The subject line was blank. The attachment was a single PDF. I pulled into the parking lot of a gas station on Hillsborough and opened it. A patient intake form. A clinical document from a private psychology practice in Atlanta, Georgia, dated to the fall of 2013. The patient's name had been fully redacted, black bar across every instance, thorough and deliberate. But the patient identifier at the top of the form, the internal code used to track the file, read FW. And the intake notes were in the structured format used by HIPAA-compliant practices before the widespread adoption of electronic records. I read the clinical notes twice. I had reviewed enough intake forms in my career, written enough of them to recognize the specific constellation of presenting behaviors documented on those pages. Attachment exploitation, instrumental relationship formation, documented pattern of using therapeutic proximity as a mechanism for personal leverage. The notes were precise. They described someone who was intelligent, charming, and entirely strategic about the formation of close relationships. Someone who had sought out therapy not to address his patterns, but to understand them better. Whoever had sent this to my private email address knew that address. That meant they knew me, or knew someone who knew me, with a level of specificity that was itself a message. I sat in the gas station parking lot on Hillsborough Pike with the engine idling and felt something cold move through me that had nothing to do with the March night. I had reviewed enough intake forms to know what kind of history produced those particular clinical notes. The question was whose history I had actually married. Thursday morning, I rescheduled my 8 o'clock drove Sloan to school and came home to a house that was very quiet in the specific way that empty houses are quiet when something in them has shifted and not shifted back. The intake form was already printed. I had done it the night before, standing at the printer in Fletcher's home office at 11 p.m. while he slept upstairs, feeding the pages through one at a time with the careful attention of someone handling something they are not entirely certain they have the right to hold. I sat at the kitchen table with the printed pages, a red pen, and a cup of coffee that went cold while I read. The form documented a patient identified only as FW male, 25 years old, at intake, presenting at a private psychology practice in Atlanta in the fall of 2013. The clinical notes were written in the structured format standard to HIPAA-compliant practices of that era, presenting concern, behavioral history, initial diagnostic impressions, treatment goals. Whoever had redacted the identifying information had done it thoroughly. Patient name, therapist name, practice name, all blacked out. What remained were the clinical observations. I read them the way I read a difficult case referral, slowly without reaching for conclusions, letting the pattern emerge from the data rather than fitting the data to a pattern I already suspected. The presenting behaviors documented on those pages had a specific clinical signature: narcissistic adaptation, not narcissistic personality disorder in the diagnostic sense, but a learned behavioral framework in which the formation of close relationships serves primarily as a mechanism for acquiring leverage resources or social positioning. Attachment manipulation, a documented pattern of presenting as securely attached while systematically studying the relational needs of the other party and deploying tailored responses designed to create dependency. The treating clinician's summary note in the clipped language of a professional who has chosen words carefully. Patient demonstrates above average intelligence combined with significantly compromised capacity for genuine relational reciprocity. Therapeutic progress, limited by patient's apparent instrumental orientation toward the treatment relationship itself. That last line, I read it 3 times. An instrumental orientation toward the treatment relationship itself. The patient had come to therapy not to examine his patterns but to understand them more precisely. He had used the clinical environment the way a student uses a library, extracting what was useful and leaving. I called Archer at 9:15. He had been working since early morning. He told me he had traced the anonymous sender as far as he legally could without a subpoena. The Proton Mail account had been created 7 days before the email was sent and had not been used since. The VPN routing terminated at a commercial medical records archiving service in Atlanta that contracted with private practices for long-term document storage. Someone with access to that archive, an employee, a former clinician, someone with authorized credentials, had deliberately retrieved the file and sent it to my private email address. "This was given to you," Archer said. "Someone with inside access decided you needed to see this. They were careful, but they wanted you to find them eventually." I asked if he knew who. He said, "Not yet. But whoever it is, they've been sitting on this for a while. This wasn't an impulsive decision." I noted in my observation notebook and also in the back of my mind, in the part that would eventually need to account for this in legal terms, that the document existed in genuinely murky territory. A redacted patient file leaked from a clinical archive by an anonymous source was not something I could walk into a courtroom with on its own. It would need independent corroboration before it became legally useful. I was not going to make the mistake of treating it as more than what it was, a piece of information pointing me in a direction, not a weapon I could deploy. What it pointed me toward was Archer's second document, which arrived in a file transfer to the disposable phone at 11:30 that morning. An APA conference program. October 2014, Nashville. The American Psychological Association's Regional Graduate Research Symposium held at the Vanderbilt University Conference Center. Archer had pulled it from the APA's Historical Archives database, public access available to any credentialed member or researcher. The conference program listed all registered attendees alphabetically. Fletcher Whitmore, registered as a general attendee, listed under guest registration. Age 31 at the time. No institutional affiliation listed. The research panel he had registered to attend was titled Trauma Bonding and Therapeutic Proximity: Emerging Frameworks in Relational Exploitation. The panel presenter was listed as Dr. Nadine Cole, my maiden name, my first public academic presentation. I had been 22 years old, a second-year graduate student at Vanderbilt, and I had spent 4 months preparing a 20-minute presentation on the ways therapeutic relationships can be exploited by patients with instrumental attachment orientations. I had been nervous enough that I had written the opening paragraph on an index card and read it verbatim. I keep coming back to the memory of the coffee afterward. A man had approached me near the refreshment table, tall, well-dressed, unhurried in his manner. He had asked intelligent questions. He had referenced specific language from my presentation in a way that suggested he had actually listened. He had bought me a coffee from the urn at the back of the room and said, in a tone of genuine seeming curiosity, "Your framework for instrumental attachment, do you think the subjects are aware of what they're doing, or is it largely unconscious?" I had said I thought it was usually somewhere in between. Conscious enough to be strategic, unconscious enough to feel authentic. He had nodded slowly as though this confirmed something. I had thought it was networking. I had given him my card. 16 months later, he had proposed on the rooftop of a restaurant on Broadway that he had researched for 3 weeks in advance. At a time of evening he had confirmed would have the right light, with a ring that was exactly the type I had mentioned offhand once in a conversation I had forgotten, and he had not. Archer told me with the particular quiet he uses when he knows information is going to land hard, and he wants to give it the room it needs, that the Atlanta intake file covered the treatment period of August 2013 through October 2014. Fletcher had been in clinical therapy for 14 months. The treatment ended the same month as the APA conference, the same month we met. He had been in therapy learning the precise vocabulary of his own behavioral patterns in a city 300 miles away for over a year before he walked up to a graduate student's refreshment table and asked her an intelligent question about instrumental attachment. I sat at the kitchen table for a long time after Archer and I hung up. The red pen was still in my hand. I had not written anything on the printed form. The weekend that followed had a quality I can only describe as the calm before a reckoning. Fletcher was home both days Saturday, a slow morning with Sloane in the backyard. Sunday, a dinner he cooked from a recipe he had been wanting to try. I moved through both days with the practiced steadiness of someone who has decided what they are going to do and is simply waiting for the correct moment. I smiled at the right times. I asked about his week. I watched him across the dinner table on Sunday night and thought 14 years. He had 14 years on me before I even knew the game was being played. By Sunday evening, I had convinced myself I was prepared for whatever came next. I was wrong. Monday morning, my clinic phone rang at 8:15, the number listed on the practice website available to any patient or professional who needed to reach me. A woman's voice, measured and precise, said, "Dr. Whitmore, my name is Celeste Harmon. I think we need to talk." I agreed to meet Celeste Harmon that same Monday afternoon, not at her office or mine, but at the 404 Kitchen on 12th Avenue South, a restaurant where the booths are deep-backed leather and the ambient noise from the open kitchen runs at a consistent level that makes private conversation possible without lowering your voice to a whisper. I had eaten there twice before with colleagues. I had never gone there for a meeting I was genuinely uncertain about. I arrived 5 minutes early. Celeste Harmon arrived exactly on time, which told me something. She was not what I had constructed from Archer's reports and 11 travel itineraries, and a name written in the margins of hotel reservations. I had built a mental image from those materials assembled the way you assemble a clinical picture before the patient walks through the door, and the woman who sat down across from me did not match it in any of the ways I had anticipated. She was composed, well-dressed in the specific way of someone who has worn expensive clothes long enough that they no longer think about it. She was 44 years old, and she looked, I noticed this in the first 30 seconds, like someone who had also not been sleeping. Not the sleeplessness of guilt. The sleeplessness of someone who has been carrying a problem that requires more than one person to solve. She ordered water. She placed her phone face down on the table, which I recognized as a deliberate signal I am not recording this, and I am not distracted. She said, "I know what you're doing. I know because I've been doing the same thing for 6 months, and I think we can help each other." I did not confirm or deny what I was doing. I said, "I'm listening." She explained it the way someone explains a thing they have rehearsed until the emotion has been separated from the facts, numbered, sequenced without inflection. 3 years ago, Harmon Development Group had engaged Fletcher Whitmore's firm to redesign their primary commercial property in Chattanooga, a mixed-use development that was the centerpiece of the company's Southeast portfolio. The contract value was substantial. The timeline was 18 months. Over those 18 months, Fletcher had systematically redirected $47 million in design contracts. The work orders flowed through Whitmore and Associates on paper, establishing a legitimate paper trail of professional services. The actual design work was then subcontracted to a smaller firm at approximately 20% of the contracted rate. The difference moved through Whitmore Design LLC, the shell company, and out through the account chain that Archer had already traced to the Cayman structure. But the financial fraud Celeste said was only part of it. He took our CAD files, she said. The entire design library, 3 years of proprietary architectural drawings, structural models, site analysis data. He had system access as the contracted architect of record. He used that access to copy the files to an external server. He's been presenting our designs as his own firm's original work for 2.5 years. She said it with the specific flatness of someone who has said it before, to attorneys and investigators, and possibly to a mirror, and has reached the stage of anger that has burned down into something colder and more durable. I asked how she had discovered it. One of my design directors recognized a rendering in a trade publication. She said, a project Fletcher's firm was presenting as an original design concept. She had drawn that rendering. She still had the original file with the creation timestamp and her employee metadata embedded in it. She placed a USB drive on the table between us. Not pushed toward me, placed equidistant in the center of the table. She let me decide. That drive contains the forensic accounting report commissioned by our legal team from a licensed firm in Atlanta. It also contains the original CAD files with embedded metadata, the subcontractor billing records, and the contract trail. The accounting report alone runs 240 pages. She paused. I have everything except someone who isn't me standing beside me when this goes to court. Fletcher's attorneys will characterize this as a business dispute and a bitter ex-business partner's vendetta. I need a corroborating witness with a different relationship to the underlying fraud. I looked at the USB drive for a moment, then I picked it up. I told her I needed 48 hours to have a licensed investigator verify the files independently before I made any commitments. She said she understood that completely. She said she would have done the same. She stood to leave, put on her coat with the practiced efficiency of someone who schedules every motion, and then paused. Dr. Whitmore, she said, I'm aware of the insurance policy. I found out approximately 3 months ago from a document that came to me through channels I'm not going to describe today. The moment I understood what it was, I ended all contact with Fletcher. I need you to know that not because it changes what he did, but because you deserve to have the complete picture of what I knew, and when I knew it. I held her gaze across the table. I am trained to evaluate the difference between a statement made for effect and a statement made because it is true. What I read in Celeste Harmon's face in that moment was not performance. It was the specific discomfort of a person delivering information they have been sitting with long enough that carrying it has become its own kind of damage. I said, I'll be in touch within 48 hours. She nodded once and left. I watched her move through the restaurant, measured, unhurried, not looking at anyone, and thought about the specific irony of sitting in a Nashville restaurant with a USB drive in my coat pocket and a forensic accounting report that might be the most important document in my marriage. I also thought about the insurance policy. Celeste had said she found out 3 months ago. She had not reported it, not to the insurer, not to law enforcement. I recognized with the particular clarity of someone who has spent 10 years in a profession that requires ethical precision, a legally complicated omission. It did not make her my enemy. It made her someone who had also been managing a situation she did not fully know how to handle. I paid for my coffee, left a 20% tip, and walked out into the March afternoon. The USB drive sat in my coat pocket, small and dense, with 240 pages of forensic accounting and 3 years of stolen design files. What I didn't know yet was that 2 other people had been carrying their own pieces of this story in silence, one for 9 years, one for 14 months, and one of them was already heading toward my front door. I came home Tuesday evening to find a dark green Jaguar parked against the curb in front of the villa engine off, a man sitting alone in the driver's seat with no indication that he intended to leave. I pulled into the driveway and sat in my car for a moment, watching him in the rearview mirror. He didn't move. He wasn't on his phone. He was simply sitting. In the specific stillness of someone who has made a decision and arrived at the location of that decision and is now giving himself one final opportunity to reverse it. I got out and walked to the driver's side window. He lowered it. He was 52 years old, gray at the temples, with the particular build of a man who had spent decades on construction sites before moving into an office, broad through the shoulders, careful in his movements. He introduced himself as Dr. Owen Rafferty and said he was a structural engineer. He said he had worked with Fletcher Whitmore on 4 major projects between 2010 and 2019. He said he had not come to apologize exactly. He said he had come because he was tired. I brought him inside. Sloane was upstairs in her room, and Fletcher had not yet returned from his office downtown, a gap of perhaps 40 minutes that felt in that moment like exactly the right amount of time. I offered Owen water. He declined. We sat in the living room with the specific arrangement of 2 people who are not comfortable and are not pretending to be. He said, "I need to tell you something that I should have told someone a long time ago. I'm going to ask you to let me get through all of it before you respond." I told him to take whatever time he needed. He told me about 2013. Fletcher had approached him midway through their second collaborative project, a commercial development in Brentwood, with what Owen described as a financial arrangement. Fletcher had obtained documentation relating to a professional liability claim from early in Owen's career, a structural engineering dispute that had been settled quietly out of court, before it could affect Owen's professional license or his firm's reputation. The settlement had been sealed. Owen had believed it was buried. He laid the file on the table between us. Owen said, and he gave me a choice: cooperate with him on the financial reporting for our current and future projects, or he would ensure the claim documentation reached the Tennessee Board of Engineering and my firm's primary clients. He was specific about which clients. I recognized what Owen was describing immediately, not just professionally, but legally. What Fletcher had done in that room in 2013 was extortion under Tennessee law, and if any subsequent communication reinforcing that threat had crossed state lines by phone or email, it would constitute a federal offense as well. Either way, Fletcher had not merely built a financial crime, he had recruited his collaborators through criminal coercion and, in doing so, had committed a separate crime against each of them. Owen had cooperated. For 9 years he had reviewed and certified project financial reports he knew to be falsified. As a licensed structural engineer, his stamp and signature on project documentation carried legal weight. It represented his professional attestation that the figures were accurate and the work met code. Signing documents he knew to be false was professional fraud. In 3 specific projects where the falsified cost reports affected public access buildings, it carried potential public safety implications that Owen said he had spent 9 years not thinking about directly. In exchange, he had received offshore transfers totaling $180,000, routed through an account at a private bank in Belize that he had since closed. He told me the account was closed. He also told me with the directness of a man who has had time to think about the full picture that closing an account does not erase the transaction history. Bank records from that account could be obtained through international legal channels. He had assumed for several years that they would be. The Memphis Project, he said, unprompted. The woman who lost her property, Carol Dunning. I certified the cost overrun reports on that project. I signed my name to documents that justified $680,000 in charges that did not reflect the actual work performed. He looked at his hands. I knew at the time that something was wrong with the numbers. I signed anyway. The room was quiet for a moment. I have sat with a great many confessions in my professional life. I know the difference between a confession offered for relief and a confession offered for restitution. Owen Rafferty was not seeking absolution. He was delivering a debt he had decided he owed, regardless of whether the recipient had asked for it. He reached into his coat and placed a manila envelope on the coffee table. Inside, he told me, were his personal copies of the 3 sets of falsified certifications, the originals, which he had retained on the advice of his own attorney in the years immediately after signing them. Also, the Belize transfer records, and a signed personal statement 6 pages, detailing the full sequence of events from the 2013 meeting to the present day. I've had this envelope in my desk for 4 months, he said. I prepared it when I heard through professional channels that there was a federal financial crimes inquiry touching on account numbers connected to projects I had certified. I wanted to be the one who came forward rather than the one who was found. He stood. He said, I know this doesn't help Carol Dunning. I know it doesn't restore what was taken from the people who lost money on these projects. But I am 60 days from retirement, and I refuse to close this chapter of my life carrying what I've been carrying. I walked him to his car. I stood in the driveway on Tyne Boulevard and watched the Jaguar's taillights diminish in the direction of Belmead Lane. And I thought about the specific economy of what 9 years of coerced silence costs a person, not just professionally, not just legally, but in the smaller daily accounting of a life lived under the weight of something you cannot put down. Then I went inside, sat at the kitchen table, and called Miriam on the disposable phone. She reviewed the summary I gave her without interrupting. Then she was quiet for a moment, the particular quiet of a lawyer who is recalculating something significant. Let me be precise about where we are, she said. We now have 4 independent evidence streams, each obtained through legally documented channels, each corroborating the others. Reese Cole's financial analysis cross-referenced against public filings, Archer's account traced through licensed intelligence services with FinCEN documentation, Celeste Harmon's forensic accounting report, and the intellectual property records. And now Owen Rafferty's signed personal statement with the falsified certifications attached. She paused again. We're not building a case anymore, Nadine. We're scheduling a verdict. I sat at the kitchen table after we hung up and looked at the manila envelope on the counter next to the USB drive from Celeste, next to my observation notebook with its 41 pages of time-stamped entries. The geometry of what Fletcher had built was becoming fully visible. Not a single crime with a single victim. A system constructed over more than a decade that had required the coercion of at least one professional collaborator, the corruption of financial reporting across multiple projects, the theft of intellectual property from a major development firm, and the destruction of at least one small business owner who had simply contracted the wrong architect for a warehouse renovation. Carol Dunning had been the clearest casualty. She would not be the only name. There was one more person I had not yet accounted for, a man I had dismissed as a background figure, relevant only as a data point in Celeste's story. I was about to learn that Conrad Harmon had his own reasons for wanting Fletcher Whitmore in a courtroom, and that some of those reasons had nothing to do with justice. Archer had confirmed the USB contents by 11:30 Wednesday morning. He called on the disposable phone while I was between patients and kept it brief. The forensic accounting report was legitimate, prepared by a licensed Atlanta firm with verifiable credentials. And the CAD file metadata was clean, original creation timestamps embedded in the file, headers, employee credential signatures intact. The kind of digital evidence that holds up in court because it cannot be altered retroactively without leaving its own trace. He said, Celeste Harmon is telling the truth, the full truth, as far as I can verify. I thanked him and went back to my 11 o'clock. Conrad Harmon arrived at 3 that afternoon in a black Cadillac Escalade. He parked across the street from my driveway, not in it, and sat for a moment before getting out, the way people do when they have rehearsed what they intend to say and are taking one final pass through it. He walked across the street and stopped at the edge of my property, not the front door, and waited. I had been watching from the window. I opened the door and invited him in. He was larger than I had expected from the bankruptcy filings and the satellite imagery, and the second-hand description of a man who had lost a great deal in a short period of time. Large, quiet, with the specific stillness of someone who has spent the past 14 months learning which battles are worth the energy. He had the look of a man in his mid-40s who had recently stopped caring about the impression he made, which in my clinical experience usually means one of two things. Either someone has given up entirely or someone has decided to be honest. The distinction matters. He sat across from me in the living room and said, Celeste told me she met with you on Monday. I'm not here to confirm her version of events. I have my own. He told me about the contract. 3 years ago, Harmon Development Group had been competing for a major municipal redevelopment contract in Nashville, a mixed-use project worth approximately $18 million in architectural and development fees. Conrad's firm had submitted a proposal. So had Whitmore and Associates. The contract had gone to Fletcher's firm, awarded by a municipal review panel that included as one of its advisory members a representative appointed by Senator Barbara Holt's office. I lost $4.2 million on that decision, Conrad said. Not the contract value my preparation costs the subcontractors I had already retained. The financing I had restructured to accommodate the project timeline. I filed Chapter 7 14 months ago. My marriage ended 6 months after that, though I'll be honest with you, that was already in motion. He looked at the window rather than at me. I'm not here asking for sympathy. I'm here asking whether there's a seat at your table that hasn't been assigned yet. I told him I would consider it. After he left 40 minutes later, having said everything he had come to say, and nothing that wasn't necessary, I called Archer. Archer told me, Conrad is telling the truth about the contract loss. I verified that through public chancery court filings 3 weeks ago. His bankruptcy petition lists the Whitmore contract award as the precipitating financial event. A pause. But there's a civil suit he filed quietly in Chancery Court about 8 months ago, a breach of contract and tortious interference claim against Whitmore and Associates that he didn't mention to you. He has not disclosed it to the parties he's been approaching about cooperation. He wants financial restitution. He is here because of money, not principle. I asked if that made him unreliable. It makes him predictable, Archer said. Which is more useful? Before Conrad had left, he had placed a folder on my coffee table, set it down the way Owen had set down the manila envelope, and the way Celeste had placed the USB drive, which I was beginning to recognize as the specific gesture of people who have been carrying something they want to put down in the right place. The folder contained documentation relating to Senator Barbara Holt, a 61-year-old Tennessee state senator in her 3rd term, a recognizable name in Nashville civic circles, known primarily for infrastructure legislation and education funding. What the folder contained was less recognizable, a state development grant of $340,000, awarded to Harmon Development Group in the spring of 2021, preceded by 11 weeks by a private donation of exactly $340,000 from an LLC called Meridian Strategies to Senator Holt's Political Action Committee. A PAC, a political action committee, is a legal entity that raises and spends money for political purposes. Donations to PACs from corporate entities are subject to federal disclosure requirements and contribution limits, and they are public record. What makes a PAC donation legally and ethically problematic is not its existence, but its context, a donation that precedes a government benefit of matching value, directed toward the donor or a party connected to the donor, is the textbook definition of a quid pro quo, and quid pro quos involving government officials are the textbook definition of public corruption. Meridian Strategies, LLC. I wrote the name in my observation notebook and put a star beside it. Conrad said he had obtained the documents through his own attorneys during the bankruptcy proceedings, when they had been investigating whether the municipal contract award had been influenced by improper means. He had not used them. He said he had been waiting to understand the full landscape before he decided what to do with them. I read the folder twice. Then I called Miriam. She was quiet for a long time after I finished the particular silence of a lawyer, recalculating the weight of something in real time. When a state official receives a benefit in exchange for a government action that's state ethics violation territory, potentially criminal at the state level, she said. But if Meridian Strategies used interstate wire communication, electronic transfer, email, any cross-state line transaction to coordinate the payment and the grant award, that's a separate federal criminal matter under wire fraud statute. The FBI has jurisdiction. The The Department of Justice has jurisdiction. Another pause. This isn't a divorce with financial fraud attached anymore, Nadine. This is a federal corruption investigation. Are you prepared for what that means in practice? I told her I was. What I did not say, because I was only beginning to understand it myself, was that I had not fully considered what federal meant in the practical lived sense. Not just prosecutors and agents and grand juries, but timelines measured in years rather than months, and a visibility that could not be controlled once it began. I understood the legal architecture. I was still learning the human cost of inhabiting it. 4 days later, I found myself standing in a marble lobby at the Country Music Hall of Fame, holding a glass of sparkling water I wasn't drinking. Watching Barbara Holt work a room full of donors with the practiced ease of someone who has been doing it for 20 years. And everything became very concrete very quickly. The Country Music Hall of Fame smelled like gardenias and old money. I had been inside this building dozens of times, school field trips, a benefit concert the year Fletcher and I got engaged. A black tie fundraiser 3 Novembers ago, where he shook hands with half the state legislature, and I stood beside him in a borrowed silk dress, believing every word he said. Tonight, I wore the same shade of green, but I was not the same woman. I had memorized the room before I arrived. The Tennessee Healthcare Equity Gala drew 300 people on a Sunday evening in late March. State officials, hospital board members, real estate developers, the kind of donors whose names appeared on building plaques. I had purchased a single ticket at the patron level, $2,000 charged to my personal account, documented as a professional development expense, and told Fletcher I was attending on behalf of a colleague who had canceled. He kissed my cheek and said he had paperwork. I noted the time, 6:12 p.m. Senator Barbara Holt was working the room the way only someone who had done it for 22 years could, unhurried, precise, touching each conversation for exactly the right number of seconds before moving on. She was 61, silver-haired and sharp-jawed, in a navy dress that read as both serious and approachable. I had watched 3 video clips of her floor speeches before arriving. I knew her cadence, her tells, the particular way she paused before deflecting a difficult question. I waited until she had finished a conversation near the East Bar and was momentarily between aides. I stepped forward, extended my hand, and smiled the way I smile at new patients during a first session: open, non-threatening, calibrated. Senator Holt, I'm Nadine Whitmore. I'm a clinical psychologist here in Nashville and a constituent. I wonder if I might have 5 minutes. She took my hand, assessed me in under 2 seconds, and said, "Of course." We stepped toward the window overlooking 4th Avenue. The city glittered below us. I kept my voice low, measured, and entirely courteous, because courtesy is the correct register when you are handing someone a live wire and asking them to decide whether to hold it or set it down carefully. I want to be transparent with you, I said. I'm not here representing any organization. I'm here as a voter and as someone who is currently involved in a federal matter that touches on a 2021 state development grant, $340,000, allocated to Harmon Development Corporation. I believe you're aware of that grant. She did not change expression. That itself was information. I also want you to know, I continued, that I have a professional relationship with Graydon Allister's office. I used the word professional with precision. I was not claiming to be his ally or his informant. I was indicating proximity, enough proximity to be credible. I'm not here to make requests of you. I simply think it would be in your interest to have your own attorney review your PAC filings from that period before anyone else does. I reached into my clutch and placed Miriam Calloway's business card on the low table between us. I did not push it toward her. I left it there, face up, the way you leave something for someone to pick up on their own terms. The silence lasted 4 seconds. I counted them. Senator Holt looked at the card. Then she looked at me. Her expression was entirely unreadable, which told me she was not surprised, only calculating. She picked up the card, tucked it into the interior pocket of her jacket, and said, "I appreciate your professional courtesy, Dr. Whitmore. Then she turned signal to one of her aides with a small nod and moved back into the crowd. I stood at the window for another minute watching the city. Then I ordered a sparkling water, finished it, and went home. I heard nothing on Monday, nothing on Tuesday. I saw patients. I picked Sloane up from school and helped her finish a diorama about the water cycle. Fletcher made pasta on Tuesday night and told me about a new commission in Franklin. I listened and I asked follow-up questions and I did not feel a thing. On Wednesday morning, March 26th, Miriam called my disposable phone at 7:55 a.m., 5 minutes before I unlocked the clinic. Holt's private attorney contacted Alistair's office yesterday afternoon. She said, without preamble, "Voluntary disclosure. They're negotiating the scope." I sat in my car in the parking garage on 21st Avenue and pressed the phone to my ear, watching the concrete wall. "What does that mean for the timeline?" I asked. "It means she's protecting herself, which is exactly what she should be doing. It also means the federal office now has a second channel into the financial transactions independent of anything we've submitted. That accelerates the opening." She paused. "Graydon called me this morning before 7. He said, and I want to quote this accurately, 'Tell your client we're satisfied with the procedural integrity of the evidence chain.'" That is a very specific compliment. It took 3 days and 2 rounds of attorney negotiations. I knew because Miriam updated me each morning via the disposable phone in calls that lasted under 4 minutes. I did not ask for detail I didn't need. I wrote timestamps in my observation notebook and kept my hands steady. On Thursday, March 27th, the FBI's Financial Crimes Unit in Nashville formally opened a case file. Miriam texted me a single word on the disposable phone: "Confirmed." I was between patient sessions. I read it, locked the phone in my desk drawer, and walked back to the waiting room. Fletcher did not know. As far as I could tell, he spent Thursday at his downtown office and came home at 7 with takeout from a Thai place on Belmont Boulevard, cheerful, talking about the catering order for Saturday's party. He had invited 120 people: architects, investors, city officials, a few friends from the AIA chapter, to celebrate a new project portfolio. There would be a string quartet, he said, and a presentation screen showing the full catalog of Whitmore and Associates' work over the past 8 years. He was very proud of that catalog. That same night at 9:47 p.m., my regular phone rang. The number was unfamiliar, a 615 area code I didn't recognize. "Dr. Whitmore," said the voice. "My name is Declan Birch. I'm an investigative reporter with the Tennessean." He paused, as if giving me a moment to decide whether to hang up. "I've been working on a story about Whitmore and Associates for 11 weeks. I'm running it Saturday morning." "What time Saturday?" I asked. "Online at 6 a.m. Print edition follows." "Before the party," and I said. "Yes," he said, "before the party." I thanked him for the professional courtesy. I used the same phrase Holt had used to me because it felt right, and we ended the call. I set the phone on the nightstand. Fletcher was in the bathroom brushing his teeth. I could hear the faucet running. I lay back against the pillow and looked at the ceiling and thought about the party on Saturday night. The screen, the catalog of 8 years of work, the 120 guests. Fletcher had designed the evening down to the lighting cues. What he did not know was that someone else had quietly redesigned it. Someone who had grown up in this house, who knew where the router was, who had the password to the AV system, and who understood, with clinical precision, exactly how a room turns when the story changes. Before I show you what appeared on that screen in front of 120 people, including my husband, comment, "Ready if you've been waiting for this moment. Because after everything you've heard, you deserve to see how it ends." A reminder: this story contains fictional elements woven in for educational purposes. Some details may not reflect any single event, but the truth it points toward is one worth sitting with. If you'd rather step away now, that's completely your choice. The house on Tyne Boulevard looked exactly the way Fletcher had wanted it to look. White ranunculus and eucalyptus on every surface. A string quartet in the garden playing Debussy as guests arrived. 120 people moving through rooms that smelled like past hors d'oeuvres, and a burgundy I recognized as the case we had bought on our 5th anniversary trip to Napa. The caterers knew their lanes. The lighting was warm and directional, the kind that makes everyone look like a better version of themselves. I had spent 3 days moving through the preparations with a steadiness that surprised even me. I confirmed the floral delivery greeted the event staff by name, approved the past appetizers, and signed off on the bar placement. I walked the layout twice on Friday morning the way a surgeon walks a procedure in her mind before the first incision, not rehearsing what might go wrong, but mapping what was already in place. On Friday afternoon, I handed Archer the AV access code to the presentation system in Fletcher's study. We had tested it remotely at noon. The screen worked. The files loaded in under 4 seconds. Sloane had left Friday morning with her overnight bag and her stuffed rabbit, climbing into my mother's car with the particular ease of a child who has no reason to expect that any day is different from any other. She had turned at the end of the driveway and asked if she could stay Saturday night too. I said yes. I watched the car reach the end of Tyne Boulevard and turn south, and I thought she will not understand any of this for many years, and that is the only mercy I have left to give her. By 9 o'clock Saturday evening, Fletcher was at the peak of his social register. I had watched him perform in rooms like this before, the warmth calibrated to each guest. The self-deprecating ease that read as confidence, the way he touched your arm when he made a point so that you remembered the point as something you had arrived at together. He introduced me to 2 clients I had never met, mentioned my clinic with what sounded to anyone listening like genuine pride. I smiled. I refilled his champagne when his glass ran low. I did not think about what was coming because thinking about it was no longer useful. I had already done all the thinking I needed to do. At 9:45 p.m., I excused myself, said I needed to check something in the study, and walked down the hall. Miriam had cleared the presentation with Graydon's office on Friday afternoon. The materials on that screen were not evidence being introduced. They were already in federal hands. What Archer was doing was displaying what the public record would eventually show anyway, in a room full of people who deserved to know it. I sent Archer one message from the disposable phone. 4 words. Go ahead. Right now. Then I walked back to the living room, took a glass of sparkling water from a passing tray, and stood near the fireplace. At exactly 10 o'clock at night, the presentation screen at the far end of the main room came to life. Fletcher had intended it to display the project catalog, 8 years of Whitmore and Associates commissions, rendered in clean architectural photography, with captions in a font he had personally selected. What appeared instead was a financial summary that Archer had assembled and loaded to the system by Friday evening, tested remotely at noon on Saturday, and activated on my signal at 10 o'clock. It was clear, professionally typeset, and absolutely precise. The heading read, Whitmore Design LLC Financial Activity Summary 2022 to 2025. Below it, $8.3 million in undisclosed fund transfers moving from Whitmore Design LLC through 2 Delaware shell entities to Cayman registered accounts. A transaction chain with dates, amounts, and destination codes. A 1-page excerpt from Owen Rafferty's signed personal statement, notarized and dated March 18, 2025. A corporate filing showing the registered agent of Whitmore Design LLC, and a highlighted line identifying the principal. All of it gathered legally. All of it verified. All of it held in a federal evidence chain that had been building quietly since March 10th. While Fletcher had been making pasta and talking about Franklin commissions and buying tulips I had never liked, the room went silent in the particular way rooms do when 120 people simultaneously understand that they are witnessing something they cannot pretend they did not see. I watched Fletcher's face from across the room. It did not collapse dramatically. There was no theatrical break, no sudden movement. What happened was structural. Something behind his eyes shifted in the way a load-bearing wall shifts when the weight above it exceeds its design tolerance. The warmth he had been radiating all evening did not disappear. It simply became irrelevant, like a light left on in a room after everyone has left. He looked at the screen for 3 seconds. Then he looked across the room at me, through 120 people, through the string quartet which had stopped playing, through the ranunculus and the eucalyptus and the burgundy from our 5th anniversary. He looked at me for a long time. I looked back. I did not move. I did not speak. I held his gaze and felt for the first time in 25 days completely still. Graydon and I had agreed on the 2-minute window. He had wanted the room to see it, 120 witnesses, the kind of corroboration that no defense attorney could undo. Graydon Alastair and 2 FBI field agents entered through the garden door at 10:02 p.m. They were not in a hurry. They did not need to be. Graydon was in a dark suit. No tie, deliberately unremarkable, the kind of presence that communicates authority without performing it. Fletcher did not run. He stood very still, which I had expected. Narcissistic personalities under genuine collapse tend toward paralysis rather than flight. The same cognitive pattern that makes them so effective at control also makes them unable to process a scenario they did not construct. He had spent 14 years building a version of events. He had no protocol for a version he did not author. He was arrested at 10:08 p.m. The guests near the garden door moved back in a quiet wave. Someone set down a champagne flute on the wrong surface and it tipped slowly and no one caught it. Declan Birch, who had arrived as a named guest at 8:30 p.m. and spent 2 hours with a glass of tonic water and a very good view of the room, stepped outside at 10:10 p.m. His article went live on the Tennessean's website at 10:11. Archer found me in the kitchen at 10:30. I was sitting on the counter next to the refrigerator drinking tap water out of a glass I had rinsed myself because I did not want anything from the party. He didn't say anything. He climbed up onto the counter beside me, which he was too tall to do gracefully, and sat there. The agents were still in the study. We could hear the particular low register of official voices and the specific sound of document bags being opened and sealed. We sat there until they were finished. I don't know how long that was. Long enough that the caterers finished packing the kitchen around us without asking us to move. Long enough for the quartet to load their instruments into a van parked on the street. Long enough for the house to become quiet in a way it had not been quiet since March 4th. 3 days later, Miriam called. Fletcher had made a request through his attorney. He wanted a meeting. One visit supervised at the federal detention facility on Harding Place. Miriam said I was under no obligation to go. She used the word obligation specifically because she knew I would understand the clinical weight of it, that obligation and choice are different muscles, and she wanted to make sure I was using the right one. She was correct that I didn't have to go. I went anyway, because there was one question that no evidence file, no financial summary, no signed personal statement had been able to answer. And I had learned, a long time ago in a graduate seminar on trauma and cognition, that some questions can only be answered by the person who made the wound. I needed to hear him say it in a room where I had nowhere left to pretend. The Davidson County Detention Center on Harding Place was colder than I had expected for early April. The institutional kind of cold, the kind that comes from managed temperature rather than weather, the kind that gets into you regardless. I had been waiting 3 weeks for this visit. After Miriam called on April 1st to tell me Fletcher had requested a meeting, I spent 2 days deciding whether to go. Then another 11, waiting for the facility's visitor approval process to run its course. Federal pretrial detention operates on its own administrative clock, and it does not accelerate for anyone's need for closure. I submitted my license, my clinical psychologist credentials, a notarized form stating I was not present in any therapeutic capacity, and listed myself as immediate family, which, technically, I still was. Miriam had advised me not to discuss the evidence chain, the federal timeline, or the civil proceedings. I told her I understood. I told her I had one question, and it had nothing to do with any of those things. She said, then go ask it. The visiting room had fluorescent light that made everyone look slightly unwell. Fletcher was already seated on the other side of the tempered glass. He was wearing a gray detention uniform, and he looked smaller than I remembered, not thinner, but reduced in some structural way. The way a person looks when the social architecture surrounding them has been stripped away and there is only the person left. I recognized this as a normal perceptual response to the withdrawal of positional power. I noted it clinically and sat down. We picked up the handsets on either side of the glass at the same time. Old habit. You came, he said. I have one question, I said. Was any of it real? The silence lasted 9 seconds. In a clinical setting, 9 seconds after a direct question indicates genuine processing rather than performance. The plan was real from the beginning, he said. Before I met you, I knew who you were. I knew what your professional network would give me. That was a calculation. He paused. Around year 3, when Sloan was born, it stopped being a calculation. I don't expect you to believe that. I looked at him. I'm a psychologist. I've spent 15 years learning to distinguish a constructed narrative from genuine emotional disclosure. What I just heard registers as genuine. I paused. That makes it worse, not better. I want you to know that. Something moved across his face, not relief, but the particular expression of a person who has been accurately seen and is not sure whether that is what they wanted. The insurance policy, I said. He shifted. A financial hedge against contested divorce proceedings. My attorney will establish that before the court. He held my gaze. I need you to know I never intended to harm you, Nadine. I held it at the distance a clinician holds a patient's self-report, neither crediting it nor dismissing it, keeping it provisional until the legal process rendered its own verdict. A forged signature on a $4 million policy is insurance fraud under Tennessee state and federal statute regardless of stated intent. The court would address that. It was not my job to address it here. Sloan, he said. Not a question. The way you say a name when it is the only word you have left with full weight in it. She's okay, I said. He nodded. He did not ask for more. I did not offer more. I stood to leave, then picked up the handset one final time. Was there a version of this where you didn't become this? He looked down at the table, pale gray laminate scratched from thousands of hands resting on the same spot over years. I've been asking myself that, he said, since Saturday night. I set the handset down and walked out. The April sunlight outside was warmer than the building had prepared me for. I sat in my car in the parking lot on Harding Place and did not start the engine for a long time. I was not crying. I want to be precise about that because I have spent a great many pages being precise, and I do not want to stop now. I was not devastated. I was not relieved. I was something quieter, the particular state of a person who has received the answer they needed and is now required to figure out what to do with the fact that the answer is both true and insufficient. I sat there until it settled into something I could carry. Reese called that evening. I could hear the ambient hum of her Vanderbilt apartment HVAC through the phone. She asked how it went. He said year 3, I told her. He said it stopped being a calculation when Sloan was born. A pause. Then, understanding someone doesn't mean forgiving them, but it can be the beginning of forgiving yourself. I told her she sounded like a therapist. She said she'd learned from the best. I laughed. Small, brief, a little unsteady. Completely real. The first time in 4 weeks. The months ahead, depositions, pre-trial motions, the slow machinery of consequence I will not detail here. Fletcher's attorney filed an intent to plead in late April. Federal cases extend well beyond any single season. But that parking lot on Harding Place is where the story ends. Not because everything was resolved, not because I had what I needed to move forward cleanly, but because I sat in that car and felt for the first time since March 4th that the weight I was carrying had a definite shape, and that things with a definite shape can eventually be set down. What came after was just the rest of my life beginning, and I had, it turned out, a great deal of rest of my life left. By September 2025, I had gone 11 days without thinking about Fletcher Whitmore, and I knew that precisely because I had been tracking it the way you track a recovery, measuring the clean intervals between the pain. The house was white, small, 3 blocks from the Gulf with a screen porch that caught the evening wind off the water. I rented it for 2 weeks and told no one where we were going except Miriam, who needed to know for legal correspondence. I brought Sloane and Reese and a single bag of books I did not end up reading because there turned out to be other things to do with quiet. Reese sat on the porch most mornings with her Owen School course books spread across the wicker table highlighter in one hand, coffee going cold in the other. Final year. MACC valuation, a thesis topic she now had more primary research material for than any professor could have assigned her. Sloane had established a nightly ritual by the second evening, a run to the waterline at exactly the same hour each day, executed with the solemn dedication that 8-year-olds bring to vacation routines. I ran with her every time until my lungs felt clean all the way through. Miriam had sent the outcome summary the week before we left. Fletcher signed a plea agreement, 12 to 15 years federal sentencing with a restitution order of $12.7 million payable to Harmon Development Corporation, to the estate of Carol Dunning through Wren, and to former subcontractors. The insurance fraud charge carries a separate civil penalty currently in negotiation. His attorney will argue intent at the sentencing hearing. The court will decide what intent is worth. Celeste Harmon voluntarily stepped down as CEO and is cooperating fully with securities regulators. Owen Rafferty accepted a reduced civil penalty and retired to Vermont. Adeline Cross was dismissed from the clinic. Her license has been referred to the Tennessee Board of Examiners. Senator Holt will not seek re-election. She was not charged. Declan Birch's series ran in 4 parts across 3 consecutive Sundays in the Nashville Business Journal and was picked up by 12 national outlets. He mailed me a signed first printing. I framed it and then decided not to hang it. I used a portion of the divorce settlement to establish the Carol Dunning Financial Recovery Fund, $3.5 million initial endowment structured as a nonprofit under Tennessee law, providing restitution support to small business owners harmed by contractor fraud. Wren Dunning was appointed its first director. She sent me a handwritten note on plain paper. "My mother would have liked you. I keep it in my wallet." On the last morning in Destin, I was packing the beach bag when I found my old phone at the bottom of it, the main phone, not the disposable. The one I had used for 8 years of a life I no longer lived in. Fletcher's contact was still saved under home. I stood there for a moment. Sloane was already running toward the waterline 20 yards ahead of me. Reese was calling something from the porch that I couldn't quite make out over the sound of the Gulf. I walked to the edge of the water. I held the phone for 1 moment. Then I let the Gulf of Mexico make that decision for me. The water was warm. In September, the Gulf is always warm. If there is one thing this story of family betrayal taught me, it is this: the most dangerous lies are never the loud ones. They are the quiet ones delivered over dinner, over anniversary wine. Over 8 years of a life you built on a foundation you never thought to inspect. I am a psychologist. I spent a decade helping other people survive family betrayal, and I did not see my own coming. That is not stupidity. That is what love does. It makes even trained minds trust what they want to be true. So if you take one thing from my story, do not do what I did. Trust the quiet voice that tells you something is wrong. Your instincts are not paranoia. They are information. I also believe family revenge is not justice. What I pursued was accountability, and there is a difference. Family revenge burns the person holding it. Accountability lets you walk away with your hands clean. I believe God designed it that way on purpose. Family revenge may feel like power, but rebuilding your life after family betrayal, that is the quieter, harder, more permanent victory. If this story stayed with you, leave a comment. I read everyone. Share it with someone who needs to hear it. Subscribe so you never miss what comes next. Thank you for staying until the end. The stories ahead contain fictional elements built for educational purposes. If that's not for you, no pressure. Choose what serves you. But if you're ready, the next story is waiting.
That's all for this story today. I appreciate you watching. See you.
They say just forget. Move on like it's easy. But forgetting you feels like remembering someone I've never seen. I've been trying to erase you from the places in my mind, but the harder that I fight it, the more you're hard to leave behind. Every memory keeps slipping through the cracks I try to close, like a face I should remember, but somehow never know. Forgetting you feels impossible, like chasing something I can't hold, like trying to remember someone that I've never even known. I keep reaching through the silence for a past I can't undo, 'cause letting go of what we had feels like losing something true. Every moment turns to fragments, every thought just fades to blue, like I'm searching for a feeling that still only leads to you. Forgetting you feels impossible, like chasing something I can't hold, like trying to remember someone that I've never even known. I keep reaching through the silence for a past I can't undo, 'cause letting go of what we had feels like losing something true. If I never met you, maybe I would know just how to heal, but now every empty moment still reminds me what is real. Forgetting you feels impossible, like chasing something I can't hold, like trying to remember someone that I've never even known. I keep reaching through the silence for a past I can't undo, 'cause letting go of what we had feels like losing something true. Some days feel off, like I'm standing but still falling. A little pain, a little tired, and no one to tell it all to. There are days that feel unsteady, like I'm drifting out of place. Every step just feels so heavy, with a smile I have to fake. A little hurt I keep inside me, a little weight I always hide, and 1,000 quiet worries I've been holding deep inside. There's no one here to tell it to, no one who would understand. So I carry all these feelings like they're slipping through my hands. A little broken, little lost, trying hard to just get through. All these nights I stay awake with everything I never say to you. I keep walking through the silence like it's all I've ever known. Every crowded room reminds me how it feels to be alone. There's no one here to tell it to, no one who would understand. So I carry all these feelings like they're slipping through my hands. A little broken, little lost, trying hard to just get through. All these nights I stay awake with everything I never say to you. Maybe one day I'll be stronger. Maybe I'll learn how to speak. But for now I keep it buried in the parts of me too weak. There's no one here to tell it to, no one who would understand. So I carry all these feelings like they're slipping through my hands. A little broken, little lost, trying hard to just get through. All these nights I stay awake with everything I never say to you.